THC. This just adds the acid and makes clear that the 15% has to be present and that the sample doesn't include plant material, et cetera, because the plant material, et cetera, is in our marijuana definition.
So how does 5% low THC oil, or low THC oil being 5% by weight, how does that compare to the samples, quote unquote, of being 15% by weight or more? I'm just trying to understand what samples means and what form that applies to.
We've been round and round about the word samples, and we can't come up with a better way to describe it. That's currently in the code. It's in 13. We've just moved it over to 12, and we've got to be able to define to talk about the subject by using a word, and samples is the best one that we can come up with.
It's in current code now. So
right.
Yeah.
I'm just trying to understand. I mean, if I don't expect all my constituents to know this when I talk about this back home, but they certainly expect me to understand what I mean by this or what we mean. And I'm trying to understand. I mean, I think I understand low THC oil, that you've got, a medium, a substrate, or whatever, the oil itself, and you've got the THC in there. You separate it out 5%. I get that. I'm not following what this really means, though. I mean, is this a different thing we're talking about?
It means you've got three different substances that Georgia law addresses related to marijuana.
Okay.
The low THC oil that was created in HB1.
Okay.
THC, which is the current definition over in 13, so where you see it here in Section 2 is just a duplicate of where it's already in Title 13. And then you have marijuana. And, of course, marijuana is what we traditionally know involves the material, the plant, the seed, and what have you. That can be tested in a much different environment than THC once the plant material is removed, and this chemical is what they are actually testing for.
So you've got the plant material, I get that, and I get THC oil. This THC, what you're calling THC, this is a distilled powder, resin. What are we talking about?
Generally, it's a liquid as well, but I mean it could be in other formats. I mean it could be turned into a substance. I don't know exactly what kind of format it gets turned into, but that's why the law currently requires it to be at 15% by weight. So low THC oil, THC, once it gets to 15, and then marijuana. Plant.
So THC at 10%, 12%. What is
not? It's not covered. It's not currently covered.
But what's the distinction between that, an oily kind of thing, versus a low THC oil, which is oil?
The percentage of THC. The low THC oil is the 5%. The THC is the more than 15%. That's what you're addressing is a gap in current code.
I'm just not clear what it is we're talking about. I mean, I'm not being argumentative. I'm not. This isn't a policy. Yay, no, yay,
My
nay.
understanding is low THC oil and THC could look exactly the same to me and you. It's when they go in and chemically test it and determine the percentage of THC by weight is whether or not it would be low THC oil or it would be THC.
So a substance that's oily and it's got THC in it, if it's determined to be 10%, is it illegal THC oil that's over 5%, or is it legal THC that's under 15%?
It would not be covered by current code.
And in fact, it got posed to me, why don't we just move the THC level to 15% for low THC oil? Because, quite frankly, under 15% is not a violation of Georgia law. Is that right?
Or another way to do it would be to take the THC definition and lower it to more than 5%.
Yeah, right.
This is a provision that's been in code for quite a long time.
I'm just concerned, Mr. Chairman, the committee doesn't know what they're voting on. I mean, maybe everybody else is crystal clear on it. I'm certainly not. And I just, it's a.
That's why we're here.
So, I'll trust that everyone else understands this very clearly, because I don't.
All good questions. I just a little bit of maybe can help you just a tiny bit understand a little bit more. If you go look at Section 5 of your bill, that's current law. That's what THC is now, and THC is considered a Schedule 1 substance, and that's in 1613.25. This definition. When you look at the definition of marijuana, which is in 1613.21, it's not in your bill. It's been in prior versions of House Bill 722, but the words in it are that kind of help you go down this path. Marijuana means all the parts of the plant of the genus cannabis, whether growing or not, the seeds thereof, the resin extracted from any parts of the plant, every compound, manufacture, salt, derivative, mixture, or preparation of such plant seeds or resin, but shall not include samples as described in subparagraph P of paragraph 3 of code section 161325, and shall not include blah blah blah. So there's this interplay between the plant of marijuana, the level of THC that's in it, and how you get to Schedule 1.
Does that somehow, I guess the question we would all have is, does that somehow overcome the limitation, the 5% limitation on the oil as per HB1 of last year? In other words, do we have a conflict?
In House Bill 1, we are in Chapter 12, and there is no definition of THC. We have a definition of THC in Chapter 13.
And this bill is replicating that into 12, so that you've got the definition in both places. But I don't think that would be, your question is, does it create a,
Yeah, I think the concern, if I'm hearing and feeling Mr. Setzler, is do we have a conflict as it relates to the percentages and to what is allowable under Georgia law and what is not, and do we have a conflict that could cause confusion later on?
well, we have 3 different substances,
Mm-hmm.
and then we have a gap in between the low THC oil and the THC.
At 5% to 15%.
Right. That's currently in the law.
It would have been there.
Okay,
even
but we
if
just
wouldn't have
spoke
made
to
a
the
change
oil,
today.
though, last year, and that is the only thing that is allowable under Georgia law, and that is limited to 5.
Right.
So anything above that is per se illegal, correct?
Once if it's plant material and they can identify it as marijuana, yes. If it's not plant material and it tests out at more than 15%, then it's THC.
Say that again.
Okay. If it's the oil up to 5%, that's
Mhm.
low THC oil.
Right.
If it is still an oil or that type of format and has more than 15%, then it's this definition of THC in 13, therefore it's a Schedule 1.
Okay.
So there's not an inconsistency, there's a gap.
Okay.
So in essence, if it's above 15%, it's deemed to be,
Schedule 1.
it's
And
not
illegal.
pure THC, but it's deemed to meet the definition of this is THC.
Correct. If it's not in plant form.
And there's no circumstance here where the 15% says it's okay to have this. Its definition changes and takes you into a whole other part of the code with respect to what you've got. You've got a Schedule 1 substance, and you're subject to federal law, I guess, presumably.
Well, we've got code sections that regulate the possession of Schedule 1 substances over in 13. So this request to change the language is coming from the crime lab and based on what they find in the substance when they test it. We've replicated the language here in Chapter 12 because we use the term.